Hello, I'm Sarah Thompson-Copsey and welcome to today's session for Legal Futures on Terminal Dilapidations, a Practical Approach. Today we're going to be looking at terminal dilapidations, an area that so many lawyers do not like to deal with, and very fortunately so many lawyers don't have to deal with it because the vast majority of terminal dilapidations claims are actually dealt with very satisfactorily by surveyors, and lawyers never even hear about them. But there are occasions where the surveyors are unable, for whatever reason, to sort out the claim, and lawyers will then become involved. And although there is a specific approach to dealing with a terminal dilapidations claim, I would argue that a very practical approach, looking at where there are shortcomings in a claim for dilapidations, is going to be the easiest way of dealing with a dilapidations claim, whether you're acting for the landlord or you're acting for the tenant. So terminal dilapidations claim arises where the lease comes to an end and the tenant hands back the premises but hasn't complied with its obligation to give back the premises in accordance with the repairing covenant under the lease. And that leads to a claim only in damages, because the lease has come to an end, so there's nothing else that the landlord can do, a claim in damages for that breach of lease. As we'll see, it's not a simple case of saying, well, this is how much it would cost to put it right, and therefore I want that in the way of damages, sort of breach of contract, if you like. There are limitations on a claim that are built in automatically to the common law claim for damages, and also built in by the implication of statute on that common law claim for damages. So right at the outset, it's really important to forensically review the level of the claim. And by that, I don't mean going through every single item in the schedule of dilapidations. I mean, you could do, and some people do like to do that, but most of us would rather watch paint dry than go through every single item in a schedule of dilapidations. But I hope today, by the end of today, you'll be able to see that there are ways in which you can look at a dilapidations claim and say, I don't think that this is worth what the claim is ostensibly worth. And ways in which you can say, we need to rethink this because we need to deal with it in a different way. And the very first case that I wanted to look at was in fact a case called Business Environment against Dean Water. And it is a real horror story of what can happen if you get things wrong. So we're going to be looking today at what is meant by disrepair in the context of dilapidations. We're going to be looking at improvements and upgrades, whose responsibility is this, and who should be paying for it. And in particular, I think that's very important where we see changing markets today, not just because people are working from home, retailers move more online, but we're also seeing changing market requirements because of statute, because of the impact of the minimum energy efficiency standards. And that too will have an impact on the level of the dilapidations claim.